to everybody for sticking around and hanging in here to the last panel of the day. I hope that it's going to be really stimulating for everybody. I want to begin by introducing myself. I'm Grisez. I'm from Washington, D.C. I practice at the Freed Frank Law Firm, and in that capacity I run the pro bono program there in the Washington, D.C. office, and I personally do a lot of pro bono immigration representation. We don't have a billable immigration practice, but we do pro bono from affirmative asylum, from deport defense, and all the way up through the circuit courts of appeal, and a lot of policy work as well. I served most recently as the past chair of the ABA Commission on Immigration, so a lot of the policy work that I've done is in the ABA area, and following and collaborating very closely with Human Rights First and our colleagues there on issues of mutual concern. So I'm very, very happy to be here and talking about access to counsel with this wonderful group of colleagues. We're going to move here from whether respondents should be detained to where they should be detained to how they should be detained and under what conditions, and really talking about, the meat of it, which is moving towards outcomes and what difference does access to counsel make, and how can we improve what you heard starting off with Hiroko's presentation this morning about a pretty dismal, actually, lay of the land in terms of access to counsel here in Louisiana. We have a wonderful panel to address these issues, so I want to start out by introducing them. For those of you that know Director Juan Osuna, you may notice that we don't actually have Judge Osuna and Director Osuna on the panel this afternoon, but I'm very, very grateful to say we have a last-minute celebrity guest in the person of Judge Wayne Stagner here from the New Orleans Immigration Court. You have full bios of the other speakers in the program, but not of Judge Stagner, so I want to tell you that in his case, the first line of his bio in my book today is that he's my personal hero for coming in unexpectedly and filling this spot in the panel for us. And when we come to his part of the presentation, I want to ask him to tell you a bit more about his background, but I will tell you that he is the single judge here in the office building in New Orleans that was referenced earlier this morning. He has a non-detained docket, so although he has some experience and does some work from time to time with detained cases, which he'll tell you about, by and large, he is not hearing detained cases day in and day out. But he had a lengthy tenure at the Board of Immigration Appeals before coming onto the immigration court bench. He can tell you about that, and we are just as happy as we can be that he's agreed to fill in here for Director Osuna this afternoon. The other panelists I'm going to introduce to you just briefly, and again refer you to their more detailed bios. To my immediate left, Ken Mayeaux. Ken is the Assistant Professor of Professionalism and Practice. Is that it? For Professional Practice. See, when I don't write whole words, I make those mistakes. At the Louisiana State University Law School, and a colleague of mine for many years in the promotion of pro bono through other professional organizations. So welcome, Ken. Kim Boyle to Judge Stagner. Oh, I'm sorry, G. We've switched the order around a bit from my notes. G is Special Litigation Counsel here at the Orleans Public Defender's Office. She's been there since 2008, and before that was at the Bronx Defenders in New York. So G has a probably the closest, I think, connection to the criminal practice that we've been talking about most of the rest of the day, and the issues related to criminal conditions, criminal defense, and now beginning to address in that office the relationship between criminal issues and immigration issues. So welcome, G. And then last but not least, at the far left, Kim Boyle. And Kim is a partner at the Phelps and Dunbar law firm here in New Orleans. She served formerly as a judge pro tem in Division I of the Civil District Court here in New Orleans. Also former assistant professor of law here at Loyola, And of great interest for our purposes today, she's a past president of the State Bar of Louisiana and also the Bar Association of New Orleans. So we are going to be looking to Kim to give us some feedback from the perspective of the private bar at the end of the panel. The private bar in terms of law firm private bar and formal bar association notions about what might be done to address this crisis in immigration representation. Hiroko, I think, did lay out the facts very well this morning. 2,000 detention beds here in Louisiana every single day, 450 of them under contract with county jails, 1,250 of them privately run as opposed to government-operated facilities. And very, very instructive fact, the beds at Oakdale are operated by the BOP, the federal BOP, so those are a completely independent system and no access to legal orientation programs there at all. The statistics tell us nationally that 40% of the detention beds overall in the United States that ICE uses are in remote locations, and I hope that somebody will tell us, although I have a pretty good guess, how many of the ones in Louisiana are in remote locations, and I suspect that it's a whole lot more than 40%.
100%.
That was about my guess.
Unless you're from Bastille.
We know from Hiroko's presentation that Catholic Charities is doing the formal legal orientation program, DOJ funded through the Institute of Justice, but the 2 law school clinics are the only other source of legal orientation or legal information in all of Louisiana. As I understand it, they're the only 2 nonprofit organizations providing services here.
Serving the detained community.
Right, for detained. So extrapolating from that, that's who's getting legal information and legal orientation, but representation is yet a different story, and we're going to ask Ken and then later Judge Stagner to talk a bit about what direct representation rates are, even going beyond legal information and orientation. So that's not the bleak picture. Ken's going to give you the bleak picture in terms of what's going on here in Louisiana. Can you tell us, Ken, what is the lay of the land? What are detainees facing here? What's covered? Where are the gaps?
Well, you know, I'd really like to take y'all back before 1996, back before 1990, back in the 1980s. When they decided to build the Oakdale Federal Detention Center. And at the time that INS was deciding to build this, it was on the heels of 2 important events. It was the Mayeaux boat lift and the civil wars in Central America. We saw a large influx of people into the country. And so somebody had the brilliant idea that they would build a detention center in the middle of nowhere. And I think what you have to realize, and my experience today is so wonderful to hear people from outside of the immigration context walk into my twilight zone. Because somebody thought it would be a good idea to build a 900-bed facility in the middle of nowhere. And unfortunately, it's the reality. That model has been replicated many times over. But at the time that it was done, it was one of the first in the nation. It was one of the first in the nation. All the other detention centers were where you would expect them to be, in Miami, in New York, along the Mexico border. It wouldn't be a far stretch, but who thought that you would put an immigration detention center in the middle of Louisiana, where at the time, honestly, besides the Honduran population in New Orleans, which is very large, we did not have a very large immigrant population here. So somebody actually thought that was a bad idea, and the ACLU, along with an organization that was called the Lawyers Committee for Human Rights, sued and tried to stop the Department of Justice from building this facility. And their principal argument was that locating this facility far from the people's families in the United States, far from resources, and in the middle of nowhere would destroy their statutory right to counsel and their right to due process under the law. Unfortunately, the DC Circuit disagreed on grounds of rightness, that you had not demonstrated yet that that would in fact happen. Oakdale was built. It was burned down one time by the Cubans just 2 years after it was built. And then they rebuilt it. And it became the model for immigration detention in the United States, and the travesty that has happened here and continues to happen here in Louisiana has been replicated in other parts of the country. So, as you can tell, I am given to hyperbole, not one to hold back my emotions, and I'll try to dial it back a little bit for you. Because I'm really a relatively newcomer to this game. I was a commercial litigator in New Orleans for 15 years, clerked in federal court. I was an assistant DA. I mean, I'm on the 8th or 9th or 10th iteration of my legal career. And so it was shocking to me when I first walked into the twilight zone of immigration. And actually, before I came back to Louisiana, I had taken a stint off and was doing some pastoral work in Mexico. I was a missionary with my family, and then I was an immigration chaplain in a DHS facility in Arizona, where I got to see the trauma that people in detention face and the hurdles to access to counsel, and what a difference lawyers make in people's cases and in their lives. This allows pro se respondents to sign a stipulated order of removal, which explains the entire world of relief from removal in 2 sentences. And that is what is called a knowing and voluntary waiver of their rights under immigration law. Something that took us practitioners many, many hours and cases and time to learn can be signed with the stroke of a pen and a check on a box that someone understands their immigration rights by reading a 2-sentence summary that says, I'm giving up my immigration rights. But that's the twilight zone that we live in. We know representation makes a difference. In the limited studies that there are, the rates for grant rates go up substantially when people are represented. And I just won't get into all of the ranting that I'd like to today. So let's just start with this. Location, location, location. Earlier, most of the criticism of the immigration detention system is about putting people in remote detention centers far from their families, far from their resources. Human Rights Watch and the Department of Justice's own Office of Inspector General issued reports criticizing the ICE transfer policy. My colleague Hiroko pointed out that Louisiana is the #1 destination for intra-country transfers. So a lot of the people we see in detention were long-term residents living in Miami, living in Virginia, living in New York. One of my first really complicated cases involved a mentally ill guy from Brooklyn. And his family was in Brooklyn. The evidence about his case was in Brooklyn. His treating physicians were in Brooklyn, but he represented himself pro se at the first level down here in Oakdale. Location, location, location. #1 transfer destination. Who thought it would be a good idea to send someone from a place like New York where there are 1,200, it's 1,100 or so members of the American Immigration Lawyers Association, to Louisiana, where there are 70. In Oakdale, there's one. Oh, there's two. Members of ALA, and they're really naturally grown there because they found out that they could make a lot of money walking across the street to the immigration court. But all the lawyers that do immigration work, most of the lawyers that do immigration work are right here in New Orleans because we have an immigration court here and the INS offices, now DHS offices are here. So the real nucleus of immigration representation is right here in New Orleans. But someone thought it would be a good idea to put them in Oakdale, far away. Access to families and witnesses. This is another very significant struggle. Well, before I say that, very few immigration attorneys outside of New Orleans. New Orleans is not New York. We don't have as many large law firms, and we also don't have kind of the long institutional presence of nonprofit immigration advocacy, kind of the infrastructure, the social infrastructure that supports that work. Like my good friend Karen, who's a full-time pro bono counsel at a law firm who's all about promoting immigration pro bono work. We don't have that infrastructure here, even though we do have some larger firms. So growing that and overcoming those hurdles is very difficult. You send people far away from their families and far away from the evidence that they need. And it's not just a practical thing, it is an emotional trauma. I can't tell you the number of people that I've interviewed and I say, you've got a claim. You've got relief. Dealing with the client right now is that I just don't know if I want to sit in jail for 4 months to fight this. And this is a mother of 2 children. I just don't know if I can do this. The trauma of having to sit in jail when your family is in Florida or in New York is overwhelming for most of our clients. And so it's a very, very significant access to justice issue. I know it would have been equally hard for this young lady if she had been put in the Crone Detention Center in Miami. But at least at the Crone Detention Center in Miami, she'd be an hour drive from her parents, from the network of people that support her, and from a very large and well-established immigrant advocacy community where if she didn't have the resources to get hooked up with pro bono representation, there would be a very good chance that she could, okay, for a viable cancellation claim. Of course, Louisiana has fewer language, cultural, and nonprofit resources. As I was saying, it's not as big of an immigrant community here in Louisiana, although New Orleans is kind of that exception, where if we did all the immigration adjudication in New Orleans, perhaps that would make a lot more sense. And then I'll just talk about the volume and the speed of adjudication of the Oakdale Immigration Court. Okay, it is the rocket docket. Okay, and it really is an access to counsel issue. On the positive side, I'll say I have handled cases from first master to final in 60 days. So I've been able to handle cases that quickly. And that was great for my client who had a really simple claim, and we put it together and we went and we tried the case and they won. That's not helpful for someone who can't marshal the evidence or even find a lawyer that quickly. Oakdale has the largest number in the entire United States of America of case completions per immigration judge. according to the 2000, this was a report by Lenny Benson of New York Law School to the Administrative Conference of the United States, and these are ICE's own statistics, okay? Over 4,100 case completions per immigration judge per year. Judge Stagner, if Judge Stagner had to do 4,000 cases, I think he would have retired long ago.
Or died.
While other courts have seen their backlogs grow, the Oakdale Immigration Court saw its caseload quadruple in the years since 2005, and its backlog has not grown at all. Same 3 judges handling 4 times as many cases. Guys, something's got to give. Something's got to give. You cannot jam that many people through a system and expect that due process is going to be respected. Oakdale also has a very sad statistics that it is also one of the lowest cases, it has one of the lowest rates of applications for relief in the United States. 3%, only 3% of the cases of the respondents who go through Oakdale will make an application for relief from removal. Only 3%. Vastly different, and we're just talking about apples and apples here, guys. Vastly different when you get over to Texas. And the application rate goes up. It is the lack of access to counsel and the lack of information. And so someone who goes through a system where they receive no information, they're shuffled far away from their families, they're in horrendous trauma, and we expect them to make these just completely life-altering decisions about what they should do, and all without, adequate access to counsel. And like I said, really, the speed of adjudication makes it very hard to find a lawyer. So let's start talking about actual access. Variability of actual access to counsel at these remote facilities. First of all, let's just call it out. Oakdale is the exception. Oakdale is not subject to the National Detention Standards. And the National Detention Standards, in all of their flavors up through the PMB and DS 2011, created a series of standards that protected the right to counsel and gave the detainees special access to legal information. There's a free phone system. So my phone on my desk rings all the time, God help me, because I get free phone calls from all the detainees at these detention centers. I even get the phone calls from Chrome and from Alabama. So my first question is, where are you? No, I'm sorry, I can't take this call. Free phone calls. It's a big deal. At least they can call the people on the the list of free legal service providers, and so they can't do that if they're at Oakdale. The detention standards also mandate that any community organization that's willing to jump through some relatively low hoops can come and do Know Your Rights presentations at these facilities, not at Oakdale. When I started the program at Catholic Charities, one of the very first things I did was write the letter to Oakdale and say, I want to come give Know Your Rights presentations. That was in no response. Well, no, finally I got a response. It was no, you can't come. But it took me 2 years just to get the no response. So what have we created at Oakdale? We've created a place that is the worst of the worst of the worst in terms of access to counsel. Let's talk about phone access. So we have the free system at other places. I'll say that for me to get access to counsel at most places besides Oakdale is pretty good. I'm able to make a phone call. At Bazille, of course, I have a great relationship because I'm there all the time, but at Tensa also, a phone call, a fax letter, 24 hours in advance, and I'm able to have a non-paid, a toll-free call with my client, or I'm paying it. My client doesn't have to pay it. But that's me. I'm from here. And I'm one of the local players. Try to do that if you're a lawyer from New York, or a clinic student from New York, or a lawyer from somewhere else. And the standards vary from place to place to place. Gina has this incredible procedure where you call and leave a message. Excuse me, I'm recovering from a cold, and so
I'll cover you here by saying that I'm from Washington, D.C. I don't think of myself as a Southerner, but I have been told in some places that I sound like a Yankee on the telephone. So I can imagine that I sound far, far from what they want to hear in New Orleans.
But I just want to speak to this variability that from place to place to place, what you have to do to get in the place, it varies. So at Gina, they have this weird thing where you can call and leave a message for your client, who then has to make a request to the caseworker. And I say, why can't I send a fax to the caseworker along with my G28, which is a form that says I represent her? And then you just set up the thing. Why do I have to wait 3 days for my poor client to make a request to a caseworker who's going to send it up the line and then call me? But that's the way it works, because there's different rules in different places. And Oakdale, you can get a telephone conference with your client at Oakdale if you can get them to pick up the phone, because they just don't answer the phone. And then they take a message and they send it to the case counselor, who never calls you back. So there is no access to counsel at Oakdale. Oakdale is the worst also, because even if you go, you have to go between the hours of 9 and 3. Well, let's see, if you drive up from New Orleans, 3-something hours, and you want to have a long conversation with your client, let's say before trial, at the minute of 3 o'clock, they kick you out. No, I got trial tomorrow morning. No, sorry, visitation is ended. Even though that's not what's written in the standard, that's what happens in practice. So we've created down here in Louisiana the perfect storm for denial of access to counsel. And it happens every day. And as they push 13,000 to 15,000 people a year through Oakdale, it continues to happen. My colleagues and I, who do this work day in and day out, and I want to call up my colleague Karina from Catholic Charities in Baton Rouge, who runs the LOP up at Gina. We feel like we're just throwing life preservers to the few people that we can reach as they float by on the Mississippi River, and there's just a river of them passing through. And that's what counts for access to counsel down here in Louisiana. Okay, so I've been talking for too long. So I'm gonna, before we get to proposals for better access to counsel, I'll pass to Judge Stagner.
You were doing fine.
Can I ask you one question, Ken? And you touched on this a little bit, but because we're going to talk about possible engagement with the private bar, pro bono promotion versus obstacles to pro bono, you talked about, how long it takes to drive to Oakdale, but I wanted to ask you about, in general, in dealing with this landscape sort of geographically and otherwise, how much time do you and your students have to spend on logistical things? The driving, the calling, the looking for appointments, the finding your client. How much of your time is on logistics and not on lawyering?
It's a huge amount of the time is spent just getting to where we're going to be and then sitting around and waiting for them to bring us our client. And for the handful of lawyers, and there's only 3 or 4 lawyers who practice in Oakdale, who are able to go there and just get, 5 or 6 clients lined up and they get to see them, seriate them. We don't get to do that. We're only seeing 1 or 2 clients. And let me just mention one more thing, the kind of the local hero. I'll walk into a detention center and I'm Professor Mayeaux from LSU and they all want to talk me up about the Tigers and whatnot. But if you're not, it can be bad news. And so one afternoon we were at Basile and we had just finished our Know Your Rights program. And we walked out and we were in the lobby and 2 private attorneys from Texas had just shown up at 4 o'clock in the afternoon for an appointment with their client. And the lady at the desk said, "Sorry, no. You can't meet with your client." And I said, well, thank God that I was standing there, because I said, no, he has to be allowed to meet with his client. The facility procedure is that he can meet anytime until 10 o'clock tonight. Attorney visitation, he's in the regular attorney visitation hours, and he doesn't even have to ask you in advance. And so I know that if I hadn't been standing in that room, they would have been trying to make desperate phone calls to someone at ICE to try to say, hey, I drove all the way from Texas to see my client. 2 lawyers drove all the way from Texas to see clients at Basile and they were about to be kicked out. And how often does it happen, really? So one of my proposals for better access to counsel is the Sue the Bastards proposal that is not really at the top of my list, but that's one of the proposals that I want to talk to Katie about.
Well, is that a good place to turn to Judge Stagner? Because I don't want you to lose your other recommendations.
No, that'll do for now.
Okay, we'll come back to that.
I don't want to leave it with the Sue the Bastards thing.
Well, I won't ask him to react to that piece of the recommendation. But Judge Stagner, now, you heard the portrait that Ken has painted, what he's talking about Oakdale, and obviously you know the geography much better than I do of the detention locations here. How does that strike you? What reactions or responses do you have about the lack of coverage, the need for coverage, the representation rates here? How can you respond?
Well, my initial response is, I guess, that, well, I like the New Orleans Immigration Court better and better. We compare very favorably with those kind of numbers, and with what I would say customer service, we'll be a lot more responsive than that. I can give you a little bit of historical perspective that you might find of interest. I was at BIA when they were talking about building that place, when the Mayeaux boat lift happened, et cetera, et cetera. And it's probably obvious, although I don't hear people talk about it from time to time, but there is a very good reason why they decided to put the facilities in the remote locations. It's green, it's got 1 in the corners. It's money. They concluded that if they were out in the middle of nowhere, the rent was less, the construction cost was less, the maintenance cost was less, and other things didn't matter as much as that did. Because when I first saw the plans and I looked at the map, I said, why on earth would they put a facility out there that's going to hold hundreds of people, and there's nothing there to support it? Kim didn't say anything about it, but, and I give you the benefit of my experience. I've never been to Oakdale. I'm thinking I might go before I retire, but I may or may not. However, I have interpreters in my court every day who go to Oakdale frequently, and I have a passel of attorneys, and they're always talking about it. But they only have 1 hotel, as I understand it, at Best Western, 2 hotels. So if you have attorneys who want to come in there and work, You have to bring your own tip. I mean, and they also have a very limited number of restaurants, places if you want to get something to eat. So it literally is not designed to be friendly to people to come in from the outside to offer assistance. And I'm confident that's true, although I've never been there. I am shocked that it's as bad as you've said, although I can soften it a little bit. EOIR has come up with a standardized stipulated removal order, and it's gone from 2 sentences to 2 pages. I say that in a bit of humor, but that is a standardized order for EOIR, and a person is required to go through and sign, and then there are places on there where you're supposed to initial. But what the theory of that is, and what makes it, we'll say, work, is that, like Ken said, the people have been there and they conclude they don't like it. And what they do is they decide they'd rather surrender whatever chance they might have had. So that's not from a great deal of personal experience on the ground there, but I did stipulated removal orders for a year or 2 before that standardized thing came out. And when Mr. Weber was here, they offered me something and I looked at it and I would not take that. And I created a whole list of things, 2 or 3 pages, and had spots on there where the person had to initial this, that they were actually told this, they were told that, they understood this, they understood that. And I did, I don't know how many of them, but I did several, maybe 100, maybe more than that. And the driving force for those people was that they wanted to get out of jail and they did not want to wait. I have also had some experience dealing with at least some of the judges in Oakdale. Judge Nugent, who was there until recently, and I had our investiture on the same day. And he used to tell me about all the cases that they were doing, and I would ask him, I said, my God, I don't think I could carry that many cases. How do you actually hear them? And I got called upon to do the detained calendar in Oakdale as a replacement for somebody for a couple of days. And I told Nugent, I said, I don't do half this many cases in a master calendar. How do you do it? So he gave me a template on how that he did it. And what they call the people who wanted to get out of jail and now, they call them rollers. The cases were rollers. They're ready to roll out of here. And where I will go over the advisable rights and all that stuff until I'm absolutely sick of it, they would do it one time and they would tell everybody, you listen up, this applies to you. I do that too when I'm having a hearing, but I'll go through it about 3 times and then I'll ask them, did you hear and understand? But that's the idea of it, because it takes me 12 to 14 minutes just to go through all that stuff. And that's assuming the person doesn't have any questions. So how you can do 60 of those things in a morning? Because I typically have 15 at the 8:30, and I have 20 or so at the 10 o'clock. The 10 o'clock are ones that are master resets, and those people generally have an attorney. My 8:30 docket, if half the people have attorneys, we've had a good day. If the people in the 8:30 start asking me questions, I'm dead. Because, you can't give a guy a legal education in 15 minutes. And if they're reasonably bright, they can have another question after the first one. And so, it gets to be an issue. In terms of counsel, I have another story that might be of interest to you. Is this sound acceptable format to you?
Sure.
I was at BIA for a long time.
As long as it relates to access to counsel.
Well, it relates to one of the things that you think is important.
Okay.
I was the person at BIA who was the lead manager for the streamlining project. If there are many of you out there, you might think of that with great opprobrium. But that project moved the board from the dinosaur age up to at least the current generation, because we had about as a 7-year backlog of cases. And it just had a remarkable impact. We doubled the number of cases produced between one year and the next. And, you know, a lot of people thought that was successful. Later on down the road, some of the courts were very, very critical because we were not as careful with some of the cases as we should have been, and so there was some nasty criticism out of there. But the great thing that we got out of it was we changed the culture of the place so that we no longer spent half our lives doing boilerplate and proofreading it. And the time that we were supposed to print, we spent it actually on the facts of the case and the analysis and the adjudication. But when it was over with, they called this outside unit in to study this program and see if it was successful or not. Well, they obviously concluded it was successful. But the item that will be of interest to you is, one of the things they wanted to find out was, how many of the people had counsel and did it make any difference? I don't remember the number of people that had counsel, and I don't remember the exact number of it, did it make any difference? But I can tell you, the answer to that in the end was absolutely, unequivocally, and in a big way. And I may have said it to your group that had it before. I've had people ask that all the time, does it make any difference? And to my way of thinking, how on earth could you ask such a question? Because you compare the results got by a person who has English as their first language, and the proceeding is going to be conducted in English. They have education in that language. They are literate, fluent. Then they have college training, and that's supposed to teach them how to think a little bit. And then they have legal training, which is supposed to teach them how to deal with and manipulate the law and present a case. And you compare that to a person who doesn't speak the language, doesn't have any other training, and is probably illiterate in his own language. Which one of those do you think would win in a case that's based on intellectual application of rules? To me, that seems to be unbelievably crystal clear. And I will tell you, I don't remember the exact numbers, but it was very substantial difference on the ones who got relief if they had attorneys and if they did not. And so that was a formal thing. It was presented. It went all the way up to the Attorney General and all of its thing. And this was just one piece of it, but it was a piece of it. And I think that's true. On a personal level, I deal with people every day, some of whom are represented and some of whom are not. And I have some unrepresented people who come in, represent themselves, and they win. And it's like pulling teeth for me. I have had a person come in and file an application for adjustment of status based on an approved visa petition by a United States citizen spouse, have to reset that case 3 or 4 times because they invent new ways to make mistakes. I can go over it and try to tell them how to do it and what's required. I only have a limited amount of time in life, and I have a lot of cases, about 3,600 now. But we come up for the first hearing, the guy doesn't have his medical. We come up for the next hearing, or we say the first hearing, he's supposed to have filed his application in his packet. Well, you told me to file it by this date, and I did. Well, I don't have it in the record. Where is it? I sent it to USCIS. How am I going to look at it if you sent it to CIS? Well, I don't know. You're the government. This form the lady over here gave me for biometrics said I had to send it there. So I sent it there. All right, I don't have it, but I'm not going to deny this guy relief because he made this kind of mistake. And you go through this. And now my calendar, I'm booking out 6 or 8 months. I have been accused of having an inordinate amount of patience. But I can tell you, I get tired of being patient when things just won't move, even if it's not the person's fault. That is a trying circumstance, and I try to be as patient and sympathetic as I can. But it just drives me nuts. And it's that way with almost every, and some of them, I feel ridiculous. The guy's going to represent himself. He's going to apply for asylum. He has a fear of harm based on X. I give him the 589, and I give him the explanation. First 13 pages of this thing are just the instructions. You read those. Then you apply those instructions, you fill out the form. That's another 10 pages. By the way, it's got to be filled out in English. And if you got any kind of evidence to support it, it has to be in English, or you have to have the Spanish version or whatever the other one is, and it has to be translated, and you have to have a certificate of translation. What's a certificate of translation? I mean, there is just no end to it. And I give it to him, I tell them, go find somebody that speaks English and Spanish or whatever your language is to help you with this thing. And look for a lawyer in the meantime. And there you go. For me personally, I much prefer the person have an attorney because one, I'm more comfortable that the attorney has covered all the possibilities with them. If I'm going to have a guy that I've given him 2 or 3 continuances or he's had a year and he hadn't got an attorney, I reach the conclusion, I'm tired of this. You're going to have to represent yourself. Well, once we get down to the availability of relief, I have about 6 questions that I ask. 6 questions. I don't never have counted them, but it's probably 60 different avenues of relief that you might have, depending on all kinds of things. I feel a lot more comfortable if I have had a private attorney who has their question list out there and can ask this guy everything from how many toes he has to where he was at when he was given those toes. And they can have a chance of finding it. I only hit the high spots. You know, you got a relative, how long have you been here? And hopefully if the guy is from a Nakara country that's not even listed in the name, I might recognize it. But I'd rather the person have an attorney they could talk to about those kind of things. But if I've got to do it, that's what I do. And if he says an answer that triggers it, you know, you got your 10 years, you got a qualifying relative and whatnot, I'll tell him about it. Do you want to apply? Right? If the guy says yes, adjustment of status thing, it took me 4 continuances, now I've got a more difficult case. And I spend a great deal of time trying to get that person through the system with that. And the government does too, because by and large, I will ask the government, you have copies of this form, you have a copy of that form, da-da-da-da-da, was this approved or whatever. And in New Orleans, we're fairly fortunate. The government is generally pretty reasonable, but it kills my productivity. And you know, once they stop the non-detained cases at Oakdale, my caseload has absolutely exploded. Yeah, I have more than 3,600 pending cases right now. I think that's the largest single judge caseload in the United States. And I'm telling you, I'm not doing 4 or 5 times as many cases this year as I did last year. It's actually more difficult because the number of cases, I get lots of related pieces of paper. And I have to spend time. Entering counsel, changes of venue, just all kinds of things. So it takes a lot of time.
I wanted to ask you one more question, Judge Stagner, because you painted a pretty compelling picture of the difficulties when you're working with pro se applicants, and you're in a non-detained setting, right?
Right.
You have to tell the individual sometimes one step at a time, or give them mailing instructions, or give them tips about the type of evidence they need, or exhibits that we're missing. And I'm asking you to extrapolate a little bit, but it's not a hypothetical question. In the detained setting, with the much higher volume of cases that the detained judges have, you talked about your frustration with the pro se people coming back over and over, having to be led, you know, a step at a time. Context with the higher caseload, when the people, they can't just go home and look for a document. You know, their home and their family and their records, maybe, as Ken said, in New York or in Virginia or somewhere, and they can't go to the post office, and they don't have access to a copy machine, and there isn't any translator. So what can you surmise about what those judges face?
Well, I would really hate to have to try to deal with that, because another silent factor here is that all of us have case completion goals. The detained cases is official EOIR policy. That's the highest priority case that we have. 1, because it costs the government money to detain, but 2, they were EOIR, and I'm not supposed to be speaking for EOIR, so please excuse, but I feel pretty confident that the organization doesn't want people to sit in jail, and they don't have to sit in jail. I mean, on a humanitarian basis, that's not the preferred way of doing things. But we've got to move the cases. The people at headquarters have to answer to Congress. The judges have to answer to their assistant chief immigration judge, who has to answer to the chief immigration judge. And if you've got somebody over there who is doing twice as many cases as I'm doing, you have to be concerned that the judge might come along and ask you, your boss, why is it that you're not working as hard as Judge so-and-so? And so I would imagine that that would be extremely difficult. I think everybody wants to accord people due process of law, but that would have to have a numbing effect on the judge in that, in Oakdale or in New Orleans, we give you 60 days or 35 days, or we give you one 30-day and one continuance for 30 days, and then they have to just kind of live with that and go on unless there is some extraordinary circumstance. Extraordinary circumstance meaning you've got the individual with the initiative to identify something else he has done and some effort that he has made. In my court, when you're not doing, when things are not where they're supposed to be, I'm going to ask you, what have you been doing? Did you try to get the letter from down there? When did you write the letter? And the person who is making an effort gets more leeway than the person who is so overwhelmed and says, oh my God, I can't do this. Well, if you can't do this now, you're not going to be able to do it tomorrow, so we'll go ahead and finish the case today. And I'm guessing they probably have that to deal with in spades.
Okay, well, thank you. We're going to come back for recommendations in the second round, so I'll ask you to think about those and hold on to them a few moments. But we're going to shift gears a bit and turn to G. And let me ask you...
Oh, wait a minute.
Oh, sorry, I apologize.
I have made a grievous error, and I want to correct it right now. My ethics officer told me today that I had to tell you I am here in my private capacity, although I can be identified as a judge, and everything that I say is my personal opinion, not the opinion of EOIR, and you are not to take it as an opinion of EOIR, but as my opinion. And I apologize for not telling you earlier, and I hope you were not misled.
That is clear as a bell, thank you, Your Honor. G, can you tell us about what you see in the public defender's office? What's the relationship between what the office is facing and the immigration issues that you're discussing? And what is your office doing, or at least attempting to do, to address these issues?
Sure. So in painting in very broad strokes, there are two models of public defense, I guess you can say. There's traditional public defender offices, and there's an emerging model called holistic client-centered advocacy model. And a traditional public defender office, they're case-focused in the sense that the only thing the lawyer is focused on is the criminal case that is for the lawyer. And with the holistic advocacy model, the attorneys are focused on the client and trying to figure out how to provide holistic services to that client. Now, the Orleans Public Defenders in New Orleans is a relatively new office in the wake of pretty destructive, criminal justice system here in the wake of Katrina. There emerged a new public defender system. A lot of legal reforms were happening in terms of, and many different levels, in state level, on local levels, and obviously in the public defender office itself. And so the model that we're hoping to build and emulate here in New Orleans is obviously the holistic client-centered model. And it's a model that requires different types of resources than the traditional public defender office. And so in a holistic public defender office, obviously, as I said, your focus is the client. And the idea is that if you focus on the client and the needs the client comes with to the criminal justice system, perhaps you can stop this revolving door effect, particularly for individuals who are charged with lower level felony offenses and misdemeanor offenses. Now, if you're charged with a violent offense like murder or kidnapping or what have you, there's very limited, there's very little you could do for that person, because that person, if you're convicted, is going to face a long jail time. But if you're dealing with someone who is charged with a misdemeanor or a low-level felony, who is going to go back on the street on a relatively short time span, the idea is that you want to equip them with resources so that they won't come back into the system. And this model has been, it's a fairly new model, right? Its model has been kind of pushed to the forefront by a couple different offices in New York. There's the neighborhood Harlem Defenders in Manhattan, and then the Bronx Defenders. And the Bronx Defenders for the past couple of years have been kind of pushing this model across the country with the grant that they received at DOJ and BJA. And under this model, The idea is that you work with an interdisciplinary team of lawyers, an interdisciplinary team of advocates. And so every client is ideally represented by a team approach, right? There is a lawyer involved, there's definitely the criminal defense lawyer involved, right? And then if there's an immigration attorney involved, if the client has immigration issues, there is a civil attorney dealing with housing issues. And then there's a social worker who helps provide referrals for services, who provides counseling, who provides psychosocial evaluations if you're doing a mitigation letter on behalf of the client. And there's obviously the investigator who's doing the fact investigation and also sometimes the mitigation investigation for a sentencing letter or something like that. And then there's the paralegal / other staff who helps with the administrative aspect of that case. And so the idea is that the client will receive a wraparound service. And like I said, this is the model that Orleans Public Defenders is hoping to build on and was established under. Now, currently, what we've been doing in terms of immigration is that a couple years ago, we had a fellow, and we were very fortunate enough to have an incredibly bright young woman who came to our office as an Equal Justice Works fellow. And her focus was immigration representation and immigration law. And obviously, since Padilla versus Kentucky came out, I mean, it is our burden. I mean, public defenders have the burden at this point to advise our clients of their immigration consequences if they're non-citizens, right? And it's mind-boggling to me that, there are pro se litigants in immigration court because some of that burden falls on my shoulders these days, trying to explain to the attorneys who will then explain to their clients the immigration consequences of their cases. And it's really hard. It's really intricate. It's really difficult. I think we have, certainly sought the help from Loyola Law Clinic a few times, emailing professors there, asking for advice. But it's incredibly mind-boggling to me that individuals are supposed to go through that system without an attorney. Now, with our Equal Justice Works fellow, what she primarily did was she's a newly graduate from law school. She's done some immigration clinics in law school. She had some familiarity with the law aspect of it, but obviously she was not a trained immigration attorney. But she came in and she spent a lot of time learning the law and advising our clients and our attorneys about the legal consequences of a possible conviction and how to plea negotiate so that it can limit the collateral consequences of that conviction. And after a 2-year fellowship ended, the idea was that for our office was then to make that position permanent, with the idea that not only will we advise our clients, not only will we advise our attorneys and educate our attorneys, but also that immigration attorney who we would have hired on would go into immigration court with clients with claims, viable claims. Now, many of our clients are just undocumented laborers. And so I don't know much about immigration law, but I think those individuals definitely don't have a lot of claims, I think, to fight their removal proceedings. But I think we do have certain individuals with status, right? Certain status or certain family members here who may actually be able to fight or put forth a claim to fight their removal proceedings. And the idea was that we were going to actually follow the client into immigration court and represent them. Now, that would have been a drop in the bucket, right, in terms of representation, because we're dealing with individuals who are arrested in New Orleans Parish, at New Orleans Parish, and who have a cognizable claim in immigration court. But still, that was the idea. And we actually did an interview process. We actually was going to make an offer to a candidate, and then we hit the physical budget crisis, and so we were not able to actually go ahead with the offer. And we're still kind of meshed in this budget process and budget shortcomings. And so in the near future, I'm not quite sure if we're going to be able to bring that person on or be able to have that position available in our office. But that's definitely a model that's out there in other offices. When I was at Bronx Defenders in New York, we had an immigration attorney, a staff immigration attorney, who worked with other staff attorneys in the office and who also followed the clients into immigration court if they had a cognizable claim against removal. And it worked really beautifully because you really do have to know, and in New York, there were Granted, there were a lot more clients, a lot more non-citizen clients that we dealt with on a daily basis. Probably in New Orleans, we'll probably get one or two probably non-citizen clients a week. You know, in New York, we're probably dealing with, I mean, when I did an arraignment shift, you know, I would handle like 30 cases, and I would say, you know, good 10 people of them, like 10 of them could have been non-citizens, right? And so the volume was so much more greater, and the need was so much more greater there. But regardless, it took the, right? And so there's definitely that model out there. Now, in terms of another model, I guess, that we could talk about is the pro bono model, right? Not only can we have, you know, in-staff person that deals directly with immigration issues, but then also have a network of pro bono attorneys who work with you. And our office had some experience with this past year. We work in a fiscal year from July to June for our state budget purposes. And this past spring, when we faced a pretty grave fiscal shortfall, we had to terminate our conflict division, and we also had to suspend payments to our contract attorneys. And so what ended up happening was that we had hundreds of cases, essentially. There were conflict cases that our attorneys in our main office could not do the representation on because they were level 1 or level 2 conflicts, meaning there were other co-defendants or there were witnesses in cases where we were representing the defendants. For one reason or the other, there were conflict cases and we could not provide the representation. There were hundreds of cases where there weren't any attorneys. And so one of the things that we did was we reached out to the local law firms and created a pro bono consortium. And there were about 20 law firms that signed up in a relatively very short period of time, from about January to March. So in about 2 months' time, there were about 20 law firms that signed up and made a pledge to take about 5 cases each of these conflict cases. And so we're talking about 100 cases. Now, we had more than 100 cases, conflict cases, that were going to be out there, but 100 was a fairly good number. That would have probably taken about 30 to 40% of the cases. And so there's definitely, what that showed me at our office about the New Orleans legal community is that, I mean, there's definitely people who are interested, right, doing pro bono work, and when called to do so, they were willing to step up and offer the assistance. In a relatively short period of time, and all these attorneys, I mean, some of them had some criminal experience, or they were going to partner with attorneys in their offices who had criminal experience, but many of them did not have criminal law experience, right? They were commercial lawyers, they were transactional lawyers, what have you, but they were willing to take the burden on and do that. Obviously, you can't just give a case to a commercial lawyer and say, here's a, felony distribution case, good luck, I mean, you're not helping the client any, right? I mean, what kind of advocacy is that client going to receive? And so obviously there needs to be some mentoring of the pro bono attorneys to ensure that they're filing the right motions, that they're, and for them to be well oriented with the court system, because we have a very particular criminal court system here with very particular judges who like things done in a very particular way. And so you have to school them in the local, right, procedure and all of that as well. And so setting up the pro bono consortium was the easy part. It was then following through with the law firms, following through with the lawyers to make sure that their representation of the individuals was sufficient, was effective, and that they felt they were being guided and was receiving the support and the feedback that they needed. Another thing that, in terms of looking at a holistic model, I mean, when I was at Bronx Defenders, they had a housing lawyer that kind of worked with, that was also part of a team. And so, like I said, there was an immigration lawyer, housing lawyer, social worker, investigator, and the court staff, or court support staff. And another thing that we often run into is obviously issues with public housing, Section 8 housing, and our families of our clients getting kicked out of public housing because their son was arrested on a drug offense, right? Or a search warrant was executed in their home, and all of a sudden they're losing their Section 8 voucher. And for families, that's a huge issue. And it's a related issue, right? Because if you don't have housing, you're more likely to be in the criminal justice system, right? And if you're coming out of the criminal justice system, having a stable housing is really important, right? Having a stable place to go to is really important. And so we, our office and the legal aid, the legal aid community here, we created a listserv. I mean, it's not anything, you know, revolutionary or amazing, but we have a listserv where we continually talk to each other about civil legal questions, criminal law questions. We refer clients to each other through the listserv to ensure that clients are getting the services and their families are getting the services they need, and we're making the right connections. It's just another small piece of trying to provide holistic representation, but that's what we're able to do in the current budget situation that we're in. And so, I guess in terms of, in the immigration context and what can be taken from the criminal defense, in the criminal context, I mean, obviously we have the Sixth Amendment right to have, every indigent person has a Sixth Amendment right to have counsel in a criminal case. And everyone obviously is aware of that. But for many of our non-citizen clients, it's not the criminal case that worries them, actually. It's their immigration case that really is pressing upon them, especially if they have family members here, especially if they're here with kids. It's not the misdemeanor theft case that's worrisome. It's what's going to happen to them. Are they going to be removed? Are they going to be, you know, will they be able to come back? And so trying to provide that advice, trying to provide counsel and make that connection, I think is really critical and really, really important.
It's really instructive, and you've laid it out very nicely. I have a couple more questions, but I'm going to hold them until we get to talking about recommendations, so we get a chance to hear from Kim. Have we scared you away yet, Kim, talking about the, you hear about the logistical problems, the far away, the crushing caseloads, the problems with accessing evidence and so forth? What, sitting there with your two hats, the private law firm lawyer hat and the Bar Association sort of infrastructure type hat, how do you react to this? What do you think of that might work or not work? How do you respond to this type of representation crisis?
Okay, thanks, Karen. And I have several responses to that. First of all, good afternoon, everyone. I probably know, in fact, let me not say I probably know, I know the least about immigration law than anyone sitting in this room. So let me preface all comments by saying that. Similar also to the judge, let me also add a disclaimer. While I am the former president of the Louisiana State Bar Association, I am no longer an officer of the bar. I'm not on the board, so I am certainly not speaking for the LSBA in anything I say, and similar to the judge, I'm definitely speaking as a private citizen here. I've been on a number of panels where we talk about access to justice issues, because obviously that is one of the critical issues related to the bar and bluntly all of our obligations as lawyers in the state of Louisiana. I always start from the premise of looking at the aspirational goal under Rule 6.1 of the Rules of Professional Conduct, and I know everyone in the room is familiar with that, but I'm just going to remind you of it quickly. Every lawyer should aspire to provide legal services to those unable to pay. A lawyer should aspire to render at least 50 hours of pro bono legal services per year, and then it goes into several subsections related to that. So I always start from the premise that all of us who are licensed to practice in the state of Louisiana have an aspirational goal of at least trying to provide 50 hours. Second, from a bar standpoint, I'm not speaking for the bar, but from a bar standpoint, one of the LSBA's goal is to be an effective unified voice on issues affecting the administration of justice and access to justice. You cannot have justice if people do not have access to counsel. I think no one in this room would disagree with that basic statement, and I think the judge made that very, very clear when he talked about some of the cases that are before him. Now, going back to some of G's points about the remodeling of the public defender system in New Orleans, it's important for me to say that much of that remodeling took place as a result of the efforts of the State Bar Association, the New Orleans Bar Association, the Louis Martinet Society, and other bar associations in this state. After the criminal justice system was completely decimated as a result of Katrina, and I don't exaggerate by saying completely decimated as a result of Katrina, the state bar stepped in, all of the local bars stepped in, and they made a determination that, first of all, the system that was in place clearly was not working on behalf of those who were brought into the criminal justice system as defendants. And they made a very serious commitment from a monetary standpoint and certainly a time standpoint to try to restructure that entire system. And in fact, that's how I first got to know Derwin Button, who works with G as head of Arlene's Public Defender Service, because he and I both served on that initial board trying to come up with recommendations to have a better criminal justice system than we have in place now. So the bar has always been committed, certainly in my 25 years as a member of the state bar, but has always been committed to that. Then to go to G's next point as it relates to this kind of pro bono model, first, I'm proud to say that my firm was one of the firms that did decide to take, I think we took 8 to 10 cases, along with 19 other firms in the city of New Orleans once OPD was going through this severe fiscal crisis. But let me be clear about the role of the private bar as it relates to these issues of criminal justice. The private bar, I don't think, certainly in my lifetime, and I'm 50 years old, will ever be able to fill the gap related to ensuring that people who are in need of an attorney in the criminal justice system have one. Bluntly, that is not the role of private law firms. To be clear, private law firms are in the business of making money. I mean, now I know that the vast majority of everyone in the room works from a public interest standpoint, and that is so key to addressing most, if not all, of these issues. Secondly, I believe and recognize that the private bar has a serious obligation, and during my year as bar president, I attempted to focus on that obligation. But you will never be able to fill that 80% gap. We did a number of studies when I was bar president. There is at best an 80% of indigent defendants and even those on the civil side and what can actually take place from a private bar standpoint. That is a huge, huge, huge gap. So I don't want anyone to be Pollyanna-ish as it relates to what role the private bar can legitimately fill in light of all of those other obligations with that gap. Second of all, to bring up the term that bluntly I don't like to bring up even as a partner in a law firm, and certainly the associates don't like to hear us bring up, but private law firms focus on billable hours. Billable hours, bluntly, are not pro bono hours. While it's work that you are clearly doing, it is a client you are responsible for, just like you are responsible for any paying client that walks into the law firm. From many of the young associates' standpoint, their focus is on ensuring that they meet the requirements of the firm's quote-unquote billable hour requirement. Now, I give kudos to young attorneys, and I'll point to my colleague Brandon Davis, who's sitting here, who in addition to meeting the requirements of the firm, has made a serious commitment to also being engaged in serious pro bono activities. Brandon and I, Pablo Gonzalez, another attorney in my firm, David Korn, another partner in my firm, we've been working on a capital case for the last, 8 years, Brandon? I mean, I'm happy to say that our client recently was taken off death row, but we're still dealing with all of the other aspects. He is still incarcerated, and we're still dealing with all of the other aspects of that case. I bring that up to say that people like Brandon, Pablo, other young associates in the firm have made a serious commitment to doing this work, notwithstanding the fact that that is not part of their quote-unquote billable hours requirement. So you also have to keep that in mind when you talk about these issues. Third thing, from a private bar standpoint, standing in to kind of attempt to address some of these gaps, I look at it from a standpoint of top-down leadership. If the people at the top of the food chain believe that there should be a real serious commitment and dedication to doing pro bono in whatever form it is. I mean, G did a great job of breaking down the different models for handling pro bono services. But whether it's the holistic approach, whether it's kind of the pro bono model, or even whether or not you choose to go work for a system like Orleans Public Defender, PDS in Washington, D.C., whatever the case may be, there's got to be top-down leadership from those at the top who make the decisions in private law firms. And Karen is nodding her head. Her firm made a serious financial commitment, resource commitment to allow her to devote 100% of her time to that. So if that is not in place, I can tell you bluntly from many young lawyers' standpoints, it's not going to be as much of a priority for them to step in and try to take on these cases. And fourth, to me, relates to the issue with law schools and what law schools do and the commitment there. And I think I saw the dean here briefly. To me, this should be class 101 from the day you walk into law school through class 301 the day you walk out of law school. A school like Loyola, where you have a Professor Bill Quigley who has devoted his entire professional career to social justice issues, where you have a number of clinics, where you have courses like Law and Poverty that specifically focus on these issues. Those are the types of programs, in my view, that all law schools that are accredited by the ABA should be focused on. However, if you do not have that level of commitment when, I always say kids, I apologize, when students are coming through law school, then it's harder to develop that when they graduate, take the bar, and move into a private law firm setting. And I'll use an example as to why I think it's so important to hone it in from a law school perspective. We had a reception in our firm last night to welcome some of the new associates, and one of the associates came up to me and said, Kim, I don't know you, but I heard you speak several times when I was a student at Tulane, because you came in and you scared the living daylights out of us as it relates to things to avoid for purposes of passing the character and fitness aspect of the Louisiana Bar Association, because you're now dealing with a 35-page application, blah, 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 blah. That wasn't a relevant point. The bar, working with the law schools, goes in every year, and literally we attempt to scare the bejesus out of students about, forget whether or not you pass the substantive aspect of the bar examination. If you do not get a pass on character and fitness, you will not be a lawyer in the state of Louisiana or most other states in which you apply. So this quote-unquote scaring everyone half to death has legitimately had an impact on how students look at some of these issues, what they feel they need to do for purposes of not necessarily posting your drunken tirade on a Facebook page, etc., etc., etc. I think law schools should do the exact same thing as it relates to pro bono commitment. We have an obligation as professionals. I started from the standpoint of saying law firms are in the business of making money. They are in the business of making money. But notwithstanding the fact that law firm practice from a private sector standpoint is a business, we, along with academicians, along with religious leaders, we are professionals. And one of the things in being a professional has got to be giving back to that profession. Now, you don't have to do it necessarily like G does, where you devote all of your time to it, like Ken does, where you devote all of your time to it, being a public interest attorney, working for a clinic, etc. I have the highest admiration for people who do this on a full-time basis, because they're doing it generally with little money, very few resources, and bluntly with a whole lot of pressure from outside society. But we all can do something. We all can do something, and I do believe, and I am speaking for myself, we all have an obligation to attempt to do something. So I think it's critical to try to first draw in the organized bar associations, because they're in the best position to mobilize people on many of these issues. Many of the issues we ended up addressing was because people who do criminal defense work day in, day out brought those issues to the bar. We have a right to counsel. committee with the Louisiana State Bar Association. During my year as bar president, we put on the first Criminal Justice Summit where we can attempt to address some of these issues related to access. And I'm proud to say I think they're in their 4th year of dealing with that. We also, during my year as bar president, we had a group of lawyers come and say that there are serious issues with language access in the criminal courts. We need the bar to stand up and make a statement concerning that. So we worked with one of the professors at Loyola and we put that together. We brought it to the House of Delegates. They passed a resolution talking about the importance of having language access guidelines for purposes of individuals who, where I won't even say English is a second language, they may not be able to read or interpret English at all. So there are things that you guys who bluntly are in the trenches on the ground floor can do in bringing to the bar, where the bar can then bring it to private law firms to attempt to address. It's my understanding that the president-elect of the Bar Association, Richard Leaf, attended the early morning sessions. I would recommend that this group continue to follow up with leadership of the bar in all the respective states to ensure that these issues continue at the forefront.
Thank you, Kim. That's the most compelling, most succinct presentation imaginable about why the private bar has a role to fill but isn't, it can't fill the gap. Just because there's a shortage in representation, the answer can't be, oh, we're going to turn to the private bar and it now becomes your problem. So thank you for that.
Thank you.
I know we're at the end of our time. How about, Ruthie, can we take 5 more minutes?
Yeah, absolutely.
Okay, what I wanted to do...
I speak for all of you.
Well, we're only keeping them from the reception and who wants a drink or a cookie, right? So when we can talk about issues like this. So what I want to do is come back to each person and give them a chance to give us briefly their concluding thoughts in terms of recommendation, responses to each other too, if that fits into your recommendations, ideas that you may have gotten from one another about what we could do better to address this problem. And I'm going to start by tossing out 2. One, and I don't even know if everyone on the panel has seen it. I know some in the room have. But the New York Immigrant Representation Study Report, this is part 2 of this effort arising out of the Judge Katzman study group, Robert Katzman of the Second Circuit, just came out with this 2nd year report on their initiative, and they have come out with a recommendation for universal representation, an institutional provider model in New York, open to all, subject to only screening for income eligibility, supported by a public funding stream of new resources that does not divert existing government resources, that would rely on competitively selected nonprofit organizations to deliver the direct representation, but it would be at the largely the expense of the state and the city of New York to address the needs not only of the immigrants but of their families who are long-standing New Yorkers. So this is, I think, the first of its kind in calling for a publicly funded model for direct representation. I'll say also that the ABA in its study that came out in the spring, February, I think, of 2010, called for expansion of the legal orientation program funded by DOJ to everybody, because right now, I'm not sure of the number, I think it's about 25% of detainees nationwide only get access to that legal orientation and information, never mind representation. So the ABA has called for legal orientation for everyone, and then following that, appointed counsel for those who have been identified to have relief at mentally ill, mentally disabled, and children, because as you heard earlier today, even children in removal proceedings have no right to an appointed lawyer. One of the recommendations of the ABA is that mentally disadvantaged and children should in all cases, regardless of screening for financial eligibility, relief, or anything else, children and mentally disabled should have appointed counsel. So I'll stop at those 2 recommendations and move down the line.
I have a long list, but let me just throw out a couple of them. One thing we know is that when people go from the detained docket to the non-detained docket, the representation rates go way up. So you get them out of detention, and their likelihood of securing a lawyer and being represented ultimately is going to go up. The number of applications that are made go way, way up. So let's get them out on bond. One of the obstacles to that is that lawyers are not allowed to make limited appearances in immigration court, in for a penny, in for a pound. So if your client, you go in, you advocate on the bond, you get their bond reduced, but they still can't post bond, guess what? You get to stay on the case the whole time. Now, you know, no lawyer would be in business just to do bond hearings. So you can't make that limited appearance. So I would like to see, number one, I'd like to see the regulation officially changed. And I know it's on Ayla's comment on the regulatory docket for DOJ. But also just to begin a pilot program in Oakdale, let's say, and I will volunteer my clinic to do a bond project at Oakdale. And allow us to go and do limited appearances, appear for people for bonds, meet with them before their hearings, and represent them. One idea. Another idea is in order to support pro bono work, it really requires a lot of commitment of resources. And right now, while we have an LOP program, it is really not adequately funded to do the kind of support for pro bono work that's required. And G really had a great story about how when you ask a bunch of private lawyers to take these specialized cases, it requires a lot of support. Getting the lawyers to say yes was not that hard, but then providing the support that those lawyers needed in order to provide competent representation and have the resources that they need. Well, imagine that is 10 times more in immigration, where we're talking about accessing places, interpreters, families that are far away. So the resources that are needed to package that work, to oversee it, to make sure that the lawyers are able to do it, needs to be adequately funded. So I start out, you know, with the we're not going to get to fully funded representation, but if we're going to depend on at least on pro bono as part of the answer, we need to really, really adequately fund that. And I don't think it's that hard to do. I like to call this one the Mountain to Mohammed response, and that if you can't bring the mountain to Mohammed, if we can't bring all these a mountain of lawyers out to Oakdale to do the work, why can't we bring Oakdale to the mountain of lawyers that we have? Again, location. In Oakdale, very soon, all master calendar hearings will be conducted by video. No, not even from across the street at the Oakdale Detention Center. They won't shuffle them across the street. So very soon, 100% of master calendar hearings, these are all of our arraignments and status conferences, will be conducted by video. In Oakdale, let's just go with what we got right now, guys. 3% application rate. How many people do you think that's going to take that they're actually going to have to ship for final hearings? It's going to be a very small number. So why don't we just relocate the Oakdale Immigration Court to some reasonable place like Baton Rouge or New Orleans, where we have the lawyers, where we have the infrastructure, where we have at least a better infrastructure, where we have big law firms that might be willing to staff up and learn immigration law and take these cases. And then they still have to put those people on a bus every day and bring them somewhere. Bring them to Baton Rouge or bring them to New Orleans, where I believe there will be a substantial increase in representation. By the way, I hate video. I hate it. I think it's a deprivation of the right to counsel. But they didn't listen to me. Then my last one, and again, just in the realm of the practical, what could we do today? These transfers are ridiculous.
Be able to ask for permission to send that kind of email out. And it occurs to me that that might be beneficial. Now, I don't know if it would or not, but, you know, it's possible. And the other thing that strikes me as kind of missing in this analysis is, with all these great arguments and the way you resolve issues typically is you negotiate. And if you negotiate, you can be on one side, but if you're going to negotiate a resolution, you've got to have somebody on the other side. And I don't see the parties sitting at the other table who could say yes, no, maybe, or whatever. And if you try to negotiate with a storm, you're probably going to lose. And you don't have a point, or at least I don't see the point, to negotiate with to get an answer. Now, if we could come up with the negotiating point, you made a big step forward.
Well, to be fair, we were outside in the other room preparing for the panel when the panel before us was taking place. But I think Ruthie did indicate that representatives of ICE were invited to be present at this discussion today, and they were not able to be here. They did participate in the dialogue in Austin, and they are expected to participate again in the next one in Washington, D.C. What I can share, at least from Austin, is that it is part of their principles governing civil detention that detention locations should be, and I don't have the exact words, but I think it's near urban centers or in urban areas or something like that, to facilitate easier access to counsel. But needless to say, that hasn't happened yet, and I can't speak for them about that. And of course, EOIR doesn't control where the detention facilities are located. ICE has, in many of the facilities, as we heard earlier, built courtrooms, and I know it's happening in other parts of the country too. They're building facilities and putting in 3, 4, sometimes even 5 courtrooms, but that doesn't mean that EOIR is then placing judges in those courtrooms, and we run then also into the situation like Ken was discussing where no matter how close the detainees are, that may not mean they're getting into the same room with the judges. So I don't want to usurp at all the prerogative of those agencies to speak for themselves, and without Director Osuna, we don't have anybody who can speak to the I don't know if they're negotiations, but discussions about these issues between the parties. But it's a very important point that you make, and the goal of the dialogues overall is to get attention of all the players focused on these issues in a desire to move forward. So thank you for making that point there at the end. Now, Ruthie, should we finish? Should we take questions? Do you want to wrap up and we move questions to the reception area?
Yeah,
What's your pleasure?
Let's wrap up. Bill Quigley is going to give a few closing remarks. I'll give a few closing remarks. We can continue the conversation on access to counsel over Juan.
Okay, no desire to cut off discussion on access, but we've taken way more than our time, so I'm going to say thank you for your attention and